All right, I'm in a stationary place. Let's talk about what we learned, all right? We learned through our trials and tribulations. I didn't learn how to weld overnight. Made many mistakes before I became halfway decent at it, but there's always room for improvement. And I want to talk about some of the things I noticed. I stay alert, awake, and observant at all costs. There were a number of agents in agency, men and women, who act or operate in certain titles, who came up to me at the end and were like, that was impressive. Seen a lot of people try, never seen anybody like you. Maybe you should pursue a career in law school or go to school for this. You are very, very good and extremely sharp. You know, I always keep the lawyers' names private. I'll forever do that. Because they have a right to their anonymity, all right? However, on my way home, I'm thinking about this. I'm thinking about what this other judge has told me in the past. When I was talking about, there are no laws in the United States. And he goes, you're right. And I'm like, well, then what the fuck are we doing here? And on that particular instance, I actually took a plea deal. Before the plea deal happened, I was just a frank conversation. And he goes, you're right. There are no laws in the United States. And I go, drinking and driving isn't even against the law. Not that that's what the charge was applying to. I just pulled that out of my ass. And he said, you're right. It's not illegal to drink and drive. And I never really fully comprehended until today why that is. Later on, I learned that contract creates the law, equity follows the law, and all men are responsible for knowing the contracts they enter into. It's funny how we don't start to put these pieces of the puzzle together sooner, you know. The Heavenly Father had me involved in a case, okay? And I welcomed it with open arms. I didn't do a lot of the things I could have that would have shut this thing down in a New York second. I've time and time again shut down court cases. And on this one, I wanted to go in, and I wanted, well, let's be honest. One, I wanted to be right. I wanted to be vindicated by their own professionals. And in a lot of ways, I was, okay? But a win isn't necessarily spelled by dismissal or anything else. What I found interesting is the acquired knowledge gained. And I want to share this document with you really quick. Because in the end, in hindsight, which is always a son of a bitch, I realized what transpired. We go through the whole rigmarole. And rest assured, I rocked the prosecution a number of times. And I mean to the point where they were backtracking, backpedaling, and this and that. At the end of the day, it really doesn't matter how good you are at arguing. At the end of the day, it's how well you're able to identify a contract put before you on behalf of your estate. You see, they don't have jurisdiction over the man, they have jurisdiction over the estates, okay? And you're representing as an agent and agency the estate that is you're the beneficiary of. And as I'm traveling, I do my best thinking on the move. I realize where I fucked up. I screwed the pooch. And the Heavenly Father pointed something out to me. And I did bring it up about it being vague and ambiguous. And it was in the definitions. Let me see if I can find it real quick. The code doesn't provide, the Nebraska revised statutes do not provide a definition for residence, nor does the Department of Motor Vehicles, ladies and gentlemen. And this shit, like, I can't believe I missed this. I'm kicking myself in the ass over this. Let me find it real quick. Here it is, right here. Nope. Nope. We'll get back to that one here in a second. give me a second. I'm just doing this off the cuff, so I didn't have this pre-prepared for you. It's just going to take me a second here. I'm looking for something very specific. And for good reason. Son of a bitch, and they snuck that word in on me too. Oh, a multitude of times. Damn it. Part D of Section 7. Instructions number 7, instructions number 8. Definitions. Okay? And I'm going to go through this document and pull this thing apart. It just won't be tonight. But I want you guys to hear this. I want you to understand. Resident means a dweller, habitant, or occupant, one who resides or dwells in a place for a period of time. Do you understand how vague and ambiguous that is? How long does it require for somebody to be at a residence before they're considered a resident? What are the qualifications, statutorily speaking? Well, as far as the DMV is concerned, they never define resident and what it takes to qualify as a resident. And in the Nebraska Revised Statutes, near as I can tell, there is no definition for residence, or nothing that defines resident. A lot of times in the statutes and codes, you'll find that they're circular in nature. It'll say resident, see dweller or dwelling, and then it'll take you on a wild goose chase round and round and round in a circle, which is what I used to do back in the day, before I started to realize that everything they do is just a spin cycle. Now, I should have stricken that from this contract. Not recognizing this being a fucking contract. Not asking proper questions. Although realizing that some of the language in it was vague and ambiguous. This is the law of that particular court. And I agreed to it, ladies and gentlemen. And it wasn't hindsight. Like I said, it always gets you in the end. But the important thing is not to take defeat poorly, but to embrace it and go, okay, I really got to look at this documentation and figure out what I did. So it's in the District Court of Custer County, Nebraska, State of Nebraska plaintiff versus Derek Gonzalez, the all caps name, which is the estate, the defendant, right? I'm the beneficiary of that. But because I don't come in as a beneficiary, I now assume the liability of being the trustee, right? Because I didn't declare my position. I allowed them to presume and assume I'm a trustee. When I could have came in and cleared the record that I'm the beneficiary of this estate, how can we settle this matter? The prosecutor then comes in as the co-beneficiary or quasi-beneficiary of the matter. Instructions number 1, introduction. Members of the jury, now that you have heard all the evidence and the argument of the attorneys, which they're granting me some special right of being an attorney, quote unquote. I'm not an attorney, just a man. But again, I didn't cross that out. I should have. It is my duty to instruct you in the law. I will be reading to you a written set of instructions, not law, on the law to be applied in this case. I will now pause briefly in the reading of this instruction while the clerk of the court hands a copy of this sheet of the instructions to each of you. Now that you have the photocopy of the jury instructions in your hands, please bear in mind the following. Please read along with me as I read these instructions to you aloud. That is the proper way to enter into a contract. You must orally speak it and provide a written copy for them to look at when you're making a contract, ladies and gentlemen. Okay, and I only understand this because I study contract law, okay? Please do not read ahead. Why? Because we're going to go over it together to make sure that everybody agrees and that everybody at the end can say, I comprehend and I understand the following. Now, he did not do this with me, but he did it with the jury. Follow along at the pace of my reading. The original set of the instructions signed by me, together with any further written instructions which I may later provide, is the source of the law. We're establishing the law, ladies and gentlemen. Now, it wasn't his duty and responsibility to read this to me. It was his duty and responsibility to say, hey, did you read it? Do you agree to it? We're going to go through it part by part, and you just say whether or not you agree. Well, when he goes part by part with me, he doesn't do what he does with the jury. With the jury, he goes line by line by line by line. With me, being a competent man, competent to handle my own affairs, he says, section number 1, any disagreements? Section number 2, any disagreements? Section number 3, any disagreements? Now, what's happening is he's the referee in between the prosecutor and myself in case there be any conflict of interest that arise. Okay? How can they be a jury of your peers when they are U.S. citizens? That's a whole nother argument, but I agree with you. It's not a jury of your peers. The jury of your peers was instituted in the Federalist Papers. It did not carry on through the Constitution, although I would have loved for the language of the Constitution to have quoted the Federalist Papers and saying you have a right to a jury of your peers. Okay, so not to diminish the Federalist Papers, there's still very much you can utilize from them. There's still active documents, if you will. People call them living documents. There's still the fundamental basis and precepts of the foundation of this country. So, but what I want to point out to you guys today, and I called one of my mentors, and he just died laughing because he's been at this for 40 years, and he goes, "You're right." He goes, "I never thought about that. In all the cases I've been in," he says, "I never thought about the fact that I could cross stuff out. I make the law that I follow. I don't consent to prima facie evidence of law." So this, when it was first handed to me, was nothing more than prima facie evidence of what could be law. It didn't become law until we went through it on the record, and he said, "Do you object to anything in number 1? No, I don't. Do you object to anything in number 2? No, I don't." And I'm thinking to myself now in hindsight, I really should have slowed down. Slow down. Slow is steady, and steady is accurate, and accurate is fast, all right? So, when we start to go through the evidence from which you are to find the facts consist of the testimony of witnesses, the exhibits received, and evidence. The following things are not evidence: statements, arguments, and questions of the attorneys. Again, should have caught that. Attorneys, I wasn't an attorney on behalf of the estate. For the state and the defendant. Objections to questions, any testimony I told you to disregard, anything you may have seen or heard about this case outside of the courtroom. Now, when we watch Judge Judy, ladies and gentlemen, or Judge Joe Brown, you never see an attorney in there, all right? That's a common law venue, or the closest you're ever going to get to see a common law venue without being in camera, in chambers. Man, I learned so much. I need to start writing all this stuff down. I just noticed some more discrepancies. Hold on, let me show you something. I completely overlooked this. Damn it. You must. Now, the word must is different from the word shall. Must is mandatory. Shall is maybe, maybe not. You must apply the law in these instructions. The law in these instructions is what myself and the representative on behalf of the state have agreed to be law, ladies and gentlemen. You must apply the law in these instructions, even if you believe that the law is or should be different. Why is he saying that? Because it was me and the prosecutor who created the law. Although he created this document, or somebody in his office created this document, it did not become the law until I agreed to it, ladies and gentlemen. That's contract law 101. All right? Man, sometimes I don't understand why the Heavenly Father puts me in the places he does. You know, I thought about my emotional reaction if the jury came back as not guilty. I was afraid I wouldn't be able to compose myself. There was a part of me that thought that I really conveyed it properly. There's a part of me that said, if you prevail, keep your composure. If you lose, in this, take it as a learning lesson and go back and look at it and evaluate it and pull it apart and see what it is. And so, literally, when I lost, there's just this. When the estate got charged up, there was this sense of calm that just came over me. I'm like, okay, now it's time to break it down. What did I do? The Heavenly Father pointed out the vagueness and ambiguities in these things, and I only brought up 2 issues. And looking at this document now, and not only, I can't even blame Mark for this. It's a Jesuitical trick. I'll agree. It's a Jesuitical trick. However, he even offered me not once, but twice. Do you need a little more time to read this? Do you need a little more time to read this? And I said, no, we can go ahead. That's equity. He offered grace. Sure, you don't want more time to digest this. He offered it to me, exonerating himself from any liability. He did not instruct me that I had the ability to line out things. This is only what I am discovering from being learned and having the prosecutor in the room come up to me, because there was one instance I saw some things in here that just clearly did not apply. They just didn't apply. And I immediately drew cause to concern as I was reading it. And I said, none of this applies. You know that, right? And he's like, yeah, let's go ahead and just strike these out. Damn it, I wish I was slowing down a little bit. That amazes me. Amazes me. What a learning experience. God bless the Heavenly Father. All right. Where was it at? Where'd it go? I keep telling you, and Mark even said this from the bench. Important lesson, ladies and gentlemen. Do you remember how I always tell you the law is specific? It's specific. And he said that to me. Now, Derek, you realize the law is specific. And I said, oh, we definitely agree on the law being specific. And he said, okay, it's another notice and opportunity he was giving me. Sure, you don't want to read this a little more. The law is specific. Okay, here we go. A fact may be proved by direct evidence alone. A fact may, which means it may or it may not be. Okay, just like the word shall. By circumstantial evidence alone, or by a combination of the two. You are the sole judge of the credibility of the witnesses and the weight to be given to their testimony. In determining this, you may consider the following. All right, that's still jury instructions. Let's get to the law that I entered into. However, this contract can be challenged because it's not mutually beneficial, and there's only one party to it. The state can never come forward and say, no, you can't be out of this contract or you owe me something. Hold on. Let me think a little bit more on that. The duty is to decide whether the defendant is guilty or not guilty of the crimes charged. My duty is to decide what happens to the defendant if you decide that the defendant is guilty. You must make your decisions without considering. Okay, that's all fine and dandy. Okay, burden of proof. Proof beyond a reasonable doubt. A reasonable doubt is one based upon reason and common sense after careful and impartial consideration of all the evidence. Proof beyond a reasonable doubt is proof so convincing that you would rely and act upon it without hesitation in the more serious and important transactions of life. However, proof beyond a reasonable doubt does not mean proof beyond all possible doubt. Probably should have struck that one. I think that may be ad lib. However, nowhere in statute does it provide however, so I'm guessing that might have been ad lib added by somebody. I can say it was Mark. I have no firsthand knowledge of that, but I find it interesting. Instruction number 6, elements, effects of findings. A, separate discussion. The defendant has been charged with 2 separate crimes. You must come to a separate decision regarding each count. Remember, without a victim, they're not crimes. It's a contract. It's a civil matter. B, regarding count number 1, violation of Nebraska Certificate of Title Act. Elements. The elements of the state case are that during a period of time commencing August 18, 2020 and ending November 30th, 2020, the defendant, Derek Gonzalez, knowingly committed a fraud in any application for a certificate of title, and that these events took place in Custer County, Nebraska. Now, had I been doing my research, had I really looked at this, that should have been crossed out. The defendant, Derek Gonzalez, knowingly committed a fraud in any application for a certificate of title, and that these events took place in Custer County. First of all, these alleged events didn't take place in Custer County. Secondly, the defendant, Derek Gonzalez, the all caps name, can't do anything knowingly. That these events took place in Custer County, Nebraska. Effect of findings number 2. If you decide that the state proved each and every element of this crime beyond a reasonable doubt, then you must find the defendant guilty on this count. If you decide the state has not proven each and every element of the crime beyond a reasonable doubt, you must find the defendant not guilty of this crime. Regarding count number 2, willful evasion of sales tax. Another discrepancy. Completely overlooked. So I agreed to it. Watch. Regarding count number 2, willful evasion of sales tax. Elements. The element of the state's case are that during the period of time commencing August 18, 2020 and ending November 30, 2020, the defendant, Derek Gonzalez, purchased a 2004 Yamaha motorcycle, at the time resided in Custer County, Nebraska. That should have been struck from that document. There was no physical, equivocal evidence, whether in material fact or otherwise, that I was a resident. Why? Because nobody can define what resident is in the state of Nebraska. It is not defined. However, I freaking agreed to it in this damn contract that went before the jury, and because I agreed to it, I entered into that fucking contract. Failed to pay the sales tax imposed on the purchaser, and that these events took place in Custer County, Nebraska. Again, these events didn't take place in Custer County. Wait. Yes, These events did not take place in Custer County. Purchased a Yamaha motorcycle. At the time, resided in Custer County when he did it. Where did I just read that at? Failed to pay sales tax imposed on the purchase, and they keep calling it a purchase. Well, it wasn't a purchase, an even exchange and fair trade. And it didn't happen in Custer County. And these events took place in Custer County. Again, an egregious misnomer that I over-fucking-looked. So I consent, essentially, by silence being acquiescence. I hope you guys are paying attention to this. This shit is good. It's gold. Effective findings. If you decide that the state proved each and every element of this crime beyond a reasonable doubt, then you must find the defendant guilty on this count. If you decide the state has not proved each and every element of the crime beyond a reasonable doubt, you must find the defendant not guilty of this crime. Instructions number 7, certificate of title. The Nebraska statutes that are vague and fucking ambiguous that apply to this case provide as follows. I agreed to these stupid statutes being used, which means I agreed to them being the law of the court. A sale of a motor vehicle requires, well, my whole argument in there was that it wasn't a motor vehicle, it was a consumer good primarily used for household goods. But I consented to it being identified as a motor vehicle by not striking that out. The seller deliver to the purchaser should have struck out seller. It wasn't a seller. It wasn't a seller in that. It was an even exchange and fair trade. Deliver to the purchaser a certificate of title with such assignments thereon necessary to show title in the purchaser, and the purchaser shall not receive a certificate of title which does not contain the assignment necessary to show title in the purchaser. Again, purchaser, vague and ambiguous. Seller, vague and ambiguous. Assignment, vague and ambiguous. Okay? No names in this. The Nebraska statutes, and furthermore, all statutes are prima facie evidence of law on their face unless rebutted and rebuked. It's about an ascension of the mind, a meeting of the minds. That's what this is all about. The purchaser shall not receive a certificate of title which does not contain the assignment necessary to show title in the purchaser. Okay? Well, household consumer goods are exempt from taxation, and they're also exempt from registration. And you can't pay the taxes without registering it in somebody's name. The purchaser of a motor vehicle is required to pay sales tax, and that's true. The purchaser of a motor vehicle in the commercial law, whose primary use is for commercial purposes, is required to pay a sales tax. However, acquiring property for the primary use of leisure and pleasure as a household consumer good is not taxable. But I didn't get the law in the record. At a rate of 5.5% of the purchaser's price. There's nothing wrong with that statute except for it doesn't apply to the intent of the exchange, which is why Article 1, Section 16 is so important in the Nebraska Constitution, and Article 1, Section 10 of the American Constitution, the Constitution for the United States of America is so important because no government can impede the right to obligation of contract. They can't butt in. Wow. The sales tax imposed by the law is the liability of the purchaser of the motor vehicle and shall be collected by the county treasurer at the time the purchaser makes application for registration. Just proved my point. At the time that you apply for registration is when you pay for the taxes. Well, if you can't pay the taxes prior to registering it, then you've created an impossibility. I didn't catch that until the end in hindsight. Of the motor vehicle for operation upon the highways of the state, and then they The statute, of course, leaves out the point that for commercial purposes. Okay, here's some more. This one's good. If the purchaser, again a vague and ambiguous term, does not register the motor vehicle, was the last time you've been to a motor vehicle dealership? You've never been. They're all automotive dealerships or automobile dealerships. Within 30 days of the purchase, the sales tax imposed shall be immediately paid by the purchaser to the county treasurer. Okay, now the statute may say that, but I think this is ad lib, of the purchaser's residence. Okay, and then there's this nifty little thing, or the Department of Motor Vehicles. Ladies and gentlemen, I went to the Department of Motor Vehicles and offered to pay the tax in Lincoln, Nebraska, and they told me you have to go back to the county treasurer because the county treasurer is responsible for collecting the taxes for those who wish to use a motor vehicle on the public highways for profit and gain. This, or the Department of Motor Vehicles, I believe was added. I will go into the Nebraska statutes. I will look this up. And of course, I want to point something out. This is purported to be in the Nebraska statutes, but nowhere in here do I have an NRS number, a Nebraska Revised Statute number, so I can go and look this up, ladies and gentlemen. All right, so I actually have to type in these words and go find where it actually says that, and I bet I'm not going to be shocked at all when I realize that half of this language and lingo is not, in fact, within the Nebraska statutes. And if it is, then why did the DMV deny me the ability to pay the tax at the Department of Motor Vehicles in Lincoln, Nebraska at their headquarters? Wow, what a learning experience. Fraud is knowing misrepresentation of the truth or engaging in deceit for profit or to gain an advantage. At no point in time did I seek to deprive anybody of their life, liberty, their rights to freedom, their pursuit of happiness. In fact, I tried to assist when the treasurer was giving resilience about the tax, and I made right with the man immediately by reacquiring the private household consumer good, not primarily used for commercial purposes. Because after all, what are you going to do? Deliver pizzas or plywood on a crotch rocket? Never going to happen. Motor vehicle means any vehicle propelled by any power other than muscular power. Okay, well, I know that one exists in the statutes, but again, they don't provide the statute for that. And that was recently changed in 2021, if my recollection serves me properly. I went and looked it up the other night before court. Again, we keep addressing the elephant in the room. This is the contract. This is what I agreed to be law, what the prosecutor agreed to be law, and what the jury was presented in order to make their determination of the facts. And so nowhere in here does it say private household consumer goods. I never put this in there, and I should have. I had the right to negotiate the contract. I had the right, because under Article 1, Section 16, the contract, the right of obligation of contract cannot be impaired by government officials, agents and agency, or anything. It doesn't say they can't use trickery here's the other thing. People go, well, Derek, they didn't disclose that to you, that you could cross things out and add stuff to this. No, they did not. But did I ask? Did I ask? No, I did not. So where is the liability on their end if I failed to ask the question? You remember our brother Amicus is always like, ask questions. Ask a lot of questions. Give your dying breath asking a question. Statutes, codes, and rules are meant for all, capital letters, fiction corporations. You're correct until you agree to them binding you. All right? So let my lessons at the Hard Knocks Academy of Law be a faithful servant to you as I explain what I'm just coming to the realization of. And I called one of my mentors right away, and he died laughing because we're always, a little pissed off about some of the things that happen in a court. Most often, we never get to enjoy trial by way of jury or jury trial. Now, that brings me to another good point. I was requested by Amy to submit my rules for the jury. Now, I just foo-fooed that. In hindsight, big fucking mistake. Big mistake. I was just like, screw it. I already gave my rules orally. I'm not submitting it in writing. Words so often dissipate in the wind. Stuff on paper tends to last a little longer. And if you're really vehement about it, maybe carve it in stone. Fraud is a knowing misrepresentation. We've already been through that. Motorcycle means any motor vehicle having a seat or a saddle for the use of the operator and designed to travel on not more than 3 wheels in contact with the ground. So training wheels takes your motorcycle and makes it into something else, obviously. And riding it on a wheelie doesn't make it a unicycle, just stipulates that it can't have 3 wheels on the ground in order to classify as a motorcycle. We already covered resident, but I'm going to go over it again. Resident means a dweller, habitant, or occupant, one who resides or dwells in a place for a period of time. Now, earlier, it didn't say for a period of time. It said for a period, and then there was a comma, duration, period. Now, I made issue that there's no time that's been established. What is the amount of time that it takes to become a resident? And he said, and I quote, well, I'm not gonna dictate what the time is. Well, he was leaving it for me to dictate. 1 year, 10 years, 5 years, 6 years makes you a resident. You're making your own fucking law at this point. But because I didn't capitalize on it, and I said, well, you know, obviously there's got to be a time, a period of time. And he goes, so you want a period of time? Okay, we'll make it say a period of time. Just showing me that we can alter it at any fucking time we want because it's based upon what we agreed to, ladies and gentlemen. And the proof is in the pudding. No bullshit. That is what this says. Period of time, which is exactly what I told him. We need to establish a period of time. You know, a time frame, a timeline. He goes, well, I'm not going to do that. So you want to just put a period of time? And I'm like, well, that's still vague and ambiguous. And he goes, so what do you want to do? And I was like, well, somebody's got to establish the time. And he says, well, I mean, if you can't, you know, establish the time, then, you know, I'll just put a period of time. I said, okay, whatever, I guess. In hindsight, foobarred that deal. Foobarred that. Son of a bitch. Instructions number 9, state of mind. Knowledge is an element of fraudulently filing a financing statement, lien, or document. In deciding whether the defendant acted with the knowledge, you should consider her words. Didn't catch that one. I think he might have stuck that one in there for fun just to see if I was really reading it vehemently. Acts and all of the surrounding circumstances. I never caught that. And he may have thrown that in there. Or somebody may have thrown that in there for me. Or maybe it was the Heavenly Father said, leave that in there so he can see that. And I missed it. I overlooked it. Instructions number 10, voluntary statement. There has been evidence that the defendant made a statement to Investigator Siepkin, who is a law enforcement officer. He is not a law enforcement officer who at times acts as a law enforcement officer. That should have been corrected by me. You may rely on any such statement only if you decide beyond a reasonable doubt with regard to the statements. Here's another place that I made a fatal mistake. There were people all over the record alleging that they were public officials working at the behest of the state. None of them put their credentials on records for review. Not fucking one of them. So who's to say whether they were or were not agents, okay? They could have been people with firsthand knowledge. But as far as proving that Siepkin is a law enforcement officer, just because you carry a gun and a badge doesn't mean anything. You actually have to get that stuff established on the record. I never thought about making them provide all their credentials on and for the official record. You may rely on any such statement only if you decide beyond a reasonable doubt with regard to the statements. The defendant made the statement and the defendant understood that he was saying and what he was saying and The statement was freely and voluntarily made under all the circumstances surrounding its making. Freely and voluntarily made under all the circumstances, ladies and gentlemen. They need you to volunteer. It must be freely and voluntarily. If you decide that the state did not prove these three things beyond a reasonable doubt, then you must disagree, then you must disregard the statement, even if you think it is true. Instructions number 11, submission to the jury. I screwed the pooch on this deal. This is now ready to be submitted to you for your consideration. Any verdict you reach regarding each count must be unanimous. I screwed up bigger than fucking shit right there. Okay? I think that this would have been a different outcome had I corrected that. Had I not agreed to it, the state could have argued all day long. Of course, the state isn't really in the room because the state's no more real than Kris Kringle. The prosecutor could have argued till he's blue in the face, and I could have said, you know what? At this point, I need to speak to the man or woman that says I do them wrong, because we actually need to deliberate this, not the representer of that entity, right? Mark said, well, this is the law. This is how I have to write it. Well, knowing what I know now and thinking about it in hindsight, I had the ability not to consent to A. The case is now ready to be submitted to you for your consideration. Any verdict you reach regarding each count must be unanimous. I should have taken out, it should have been reworded. Any verdict you reach regarding each count must be unanimous in order to convict the defendant of the counts alleged. Okay? I should have corrected that. That was a big one. And I screwed the pooch. And I didn't catch it until he was actually reading it to the jury. And this is the one the Heavenly Father pointed out to me. And I said, you know what? This isn't right. You must reach your verdict based only on the evidence presented to you during this trial, with the walls of this courtroom and that general knowledge everyone has. So the general knowledge that everyone has is called customs. General knowledge is custom. Doesn't necessarily mean it's law. It means that people are accustomed to it. 1,000 people could jump off a bridge. It can become a custom. But just because every other jackass is jumping off a bridge doesn't mean that I should, that I need to, that I want to, or that it's beneficial in my life somehow. You have been allowed to take notes during the course of the trial. You may take your notes with you to the jury room for use in your deliberation. Remember, however, that your notes are not evidence. While you are in the jury room, you may not use any electronic device at all. And I agree with that. I don't think the jury should be tampered with in any way, shape, or form. I don't think they should be influenced by anybody. I think they should be left to decide on their own. No matter where you are in the jury room, at home, or anywhere else, and until after you discharged from this trial, and I tell you that it is all right to do so. Do not talk to anybody about this case except your fellow jurors, which is completely understandable. Do not use any references. And here's the other thing. It really doesn't require the jury to communicate amongst themselves. They should simply go in, cast an anonymous vote, and turn around and walk back out. But I understand sometimes in like capital crimes where somebody raped, sodomized, stole something, did a heinous act, where the jury might actually have to deliberate. We got somebody in the balance that may or may not be guilty. If he's not guilty, but the preponderance of evidence exhibited by the state, by the way, the state has a 98.3 or 6 conviction rate, okay, in Lincoln, Nebraska. That means out of all the attorneys in Lincoln, Nebraska, Lancaster County, I believe, only all the defense attorneys over there are only winning 1% of their fucking cases out of all the attorneys in Lincoln. That means the prosecuting attorney is winning 98% of the fucking time. How do these people even have jobs? How do they accept financial wherewithal from people saying that they will do their best to liberate them and free them, knowing full on well that 98.6 or 98.3% of the time, the prosecuting attorney wins? All right, how would you like to have a streak like that in Vegas? How long would you be in Vegas before every casino kicked you the fuck out because you cost them way too much money? Just think about that for a minute. There isn't a lawyer in this world that can help you if you don't become learned. And again, I point to the statistics. It was a few years back where Lincoln, Nebraska's prosecuting attorneys on behalf of the state won 98.4 or 98.6% of the time, only leaving a mere 1% for the rest of the defense attorneys to feed on. All right? So that's crazy. How can it be lawful jury trial when no man or woman has a claim against you? That is correct. You're correct on that. I'm already setting myself up on the appeal for that. Kind of gave Mark a way out because I know that the information that I have, it's hard to explain. By putting it before the jury, they've never studied what we study, all right? And it was my fear that it would cause conflict between them, not understanding the language, okay? So I put documents in the case on record, okay, for the appellate court who deals with constitutional issues, constitutional rights violations. So take judicial notice. There is no man or woman before this court bringing sufficient pleadings or sworn pleadings bonded to this case, okay? And if you want to make it a matter of law, and I believe none exist, goes on there. There's a better one yet. I can tell it to you. I think my sentence should be 7 years in law school. That's what I think I should be sentenced to on this deal. I'm going to really push for it. No matter where you are in the jury room, okay, we covered that. You will now go to the jury room. In the jury room, you will have these instructions and the exhibits in this case, and the form on which you are to record your verdict. Now, I got some stuff into the jury room, all right? Exhibits 5 and Exhibits 10. However, because I agreed to this stupid contract, how many people believe those people went and looked at my paperwork? They said, well, look at this. Then look what the state gave. What the state gave matches this. What the jury didn't recognize or have any cognizance of was the fact that I agreed to this being the law. Damn. Oh. Gold, ladies and gentlemen. Gold. Absolute gold. So you have substantive rights, you have interlocutory appeals, you have all kinds of different stuff that you can do. And when you're doing your appeals, it's one issue at a time. Do not convolute it by putting multiple issues in the same document when you're doing an appeal. Because what happens is, if they decide to strike your appeal, then you don't have the other ones to come back on because it's already been ruled on. Very, 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 very fucking important. Exchanging your views concerning this case and respectfully consider the views of the other jurors. Do not hesitate to re-examine your own views and to change your mind if you are persuaded that you should, but do not surrender your honest conviction. Now, here's the thing. I can't affirm this, all right? Because they're in the jury room, so this is just speculation on my part. Nothing more than hearsay to you, speculation on my part. There were some people that I could tell did not want to find me guilty of any of this, or the estate guilty of any of this. And you could see it in their eyes. And I was very polite to them as they left. I thanked them because it's tough for what they've got to do. Do not hesitate to re-examine your own views and to change your mind if you are persuaded that you should. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of the other jurors or for the mere purpose of returning a verdict. If you do not agree upon a verdict by 5 o'clock this afternoon, see, and this is where I should have struck this out. If you do not agree on upon this verdict by 5 o'clock this afternoon, you may determine whether you wish to work into the evening hours to as late as 9 o'clock. If you decide to work past 5 o'clock, please notify the bailiff in writing of your intention and the latest time that you intend to work. If you do not agree upon a verdict today, after obtaining leave of the court, you may separate and return for further deliberation at 9 o'clock Friday morning, which happens to be, Thanksgiving? No, he spared them Thanksgiving. But they still would have had to come back on Friday. Black Friday, which everybody wants to go shopping and do whatever they think, Consumer Nation, holiday bullshit. They structured this to be around the holiday season on purpose, all right? Because I'm formidable. And if they gave me enough time, and the jury enough time with me, I should say, there's no doubt that they would have had a really good run for their money. In the short order of time, in less than 2 days' time, I gave them one hell of a run for their money, and they know it. Before you leave for the night, you will be brought into court for additional instructions for the night. If you do separate, then during the time that you separate, you are not allowed to discuss the case with anyone, even another juror. Now, I want to draw you back to instruction A and H. A and H. This case is now ready to be submitted to you for consideration. Any verdict you reach regarding each count must be unanimous if you intend to find him guilty, is what it should have read. Because under the vague and ambiguous nature, the way they left it, this little Jesuitical trick, it leads them to believe that if they don't all agree, nobody gets to go home. Each one of them could have rendered their own individual ticket. Every last one of them could have individually said, hey, I don't need to stay here for hours on end. I'm going to go ahead and render my vote. I understand I can't leave the room, but I have to stay here until you guys vote. I've already voted. That's how it is. I'm out. I'm done. Discuss it amongst yourselves. I think that Derek did a wonderful job presenting that, and I don't find him guilty. He's not guilty on both counts as far as I'm concerned. You realize, ladies and gentlemen, out of 12 people, I just needed one to say not guilty. One out of 12 people. But because I missed this very, very, very poignant point in A, boy, oh boy, I'd love to do this again. I'd love to do this again. See, and the bar attorneys, they agree to this stuff. They agree to it on behalf of their clients. Oh yeah, that's just how we do it, baby. That's how we do it. We'll just toss it to the jury. We'll see what they say. Your lawyer's not going to fight for the fact that this is ambiguous. It's closed-ended. It makes them seem as though they have to make a unanimous decision. It should say, if the intent of the jury is to find him guilty, in order for this jury to find him guilty of all counts, it must be a unanimous decision, would be a better way of articulating that. Instead of leaving it, any verdict you reach regarding each count must be unanimous. That leads them to think, well, if Cindy and Tom and Hank think he's innocent, but we don't agree with that, we think he's guilty, we have to convince Cindy, Tom, and Hank that we're right and he's wrong, and it creates a division in the jury. It creates a division. And then they relate to the letter H, and they go, look, Tom, Henry, and Susie, you little snot rags, sniveling shit stains, if you don't agree with us, we got to come back here at 9 o'clock, we got to work late, and we got to come back on Friday, Black Friday shopping. You're going to screw our whole Christmas up, you assholes. Just agree with us. We understand that consciously you don't think the state proved it, but because of the circumstances, and Derek agreed, this is the law. They have no idea that I agreed to that. They have no idea. No idea. Damn. The lessons we learn in life. I've always said the lessons I learn are painful. They've always been painful. They're the only ones I learned from. Son of a bitch. H should have been stricken from the record because there would have been no need for H had A been explained properly. Had A been explained properly, a man would have went in there, casted his vote based upon what he thought. He may have taken the time to review the evidence. If they really thought I was guilty, they would have said, hey, we're going to be here a minute, get out all the evidence. This is a capital crime. This guy's facing life in prison. He's facing 10 years in prison. I would encourage the jury to evaluate that information a lot longer. Wow. The things you see as you actually go through your trials and tribulations. You may only discuss this case when you are in the jury room. I think that's applicable. Otherwise, you may not discuss it with anyone, even another juror. I think that's reasonable. Any reasonable, prudent man would find that to be reasonable. And here's my other thing. I wanted to wrap this up today because I'm an honorable man, and I know people are home for the holidays, and I want them to be with their loved ones. So I told the jurors that this morning. I'm going to try and get everybody out of here by noon. I'm going to be quick. I'm going to expedite my position. I'm going to do what I can in good faith to make this go quick. You must not allow anyone to converse with you at any time during your deliberation upon any matter pertaining to this case. The officer having you in charge have no right to converse with you relative to your deliberations, but only for the purpose of matters that do not pertain in any manner to the subject of your deliberation. I think that's reasonably prudent. I don't have an issue with that. I'll agree to that being law, you bet. If you have any questions, please write them out using a full-size 8.5 by 11-inch sheet of paper and give them to the bailiff, who will give them to me. I agree with that. The judge shouldn't have any contact with the jury. That could prejudice the case. A look on his face, maybe he's upset, maybe he's happy, maybe he's joking, and it could give the wrong image. So I agree with the pass-through, the bailiff being in between and in the middle. I don't see a problem with that. The foreperson should sign and date the sheet before you give it to the bailiff, okay? That's accountability, chain of title, okay? I agree with that. I may need to assemble the attorneys, okay? The attorneys should have been man, known as Derek, and the prosecutor or the plaintiff's counsel or attorney, I guess, and confer with them before I respond. Damn it. Once he read this, and I'm sitting there going, oh, fuck, I fucking fucked myself. And I walked out to the car and I told my mom, I fucked myself. She's like, what? I go, you heard those jury instructions, right? She goes, yeah. I said, I had fucking agreed to them. I agreed to them. She goes, what's that mean? I go, I'm bound by it. I don't have an argument at this point. It's done. And I was given plenty of opportunity and twice given grace and notice to, are you sure you don't want a little more time to read this? Damn. Confer with them before I respond, which is adequate. Why would he have to confer with us about the question, ladies and gentlemen? Because we're deciding the law. We're deciding what is applicable and what is not. And I crossed my fingers that somebody in that jury would go, hey, this sounds wrong. It says we got to make a unanimous decision of guilt or innocence. Maybe we should ask the judge, does that mean like if we're to find him guilty, the only way to find the defendant guilty is that if we're all in unison, but if we cast our vote and it's a mixed match, does that mean that we don't get to go home until we all either agree he's innocent or he's guilty by unanimous decision? And then we would have deliberated over that. It caught my attention. The Heavenly Father pointed out to me. I let the semantics go on. I shouldn't have. In hindsight, lesson learned. Do not call anyone, text anyone, or use Facebook or Twitter or any other social network to communicate with anyone. If you need to give a message to anyone outside the jury room, for example, to tell a family member that you will be working late, let the bailiff know in writing. I can agree with that. Your verdict must be in writing, and for your convenience, a verdict form is submitted to you with these instructions when you have all agreed upon the verdict. Now, this is where it gets fucked up, and I should have caught it, and I didn't. When you have all agreed, that symbolizes that when you have all decided to screw your fellow American man, and I'm not passing judgment on the jury. The jury was fantastic. Again, this wasn't like I beat the shit out of somebody or anything like that. This is great, guys. I don't think you realize how good it was for me being in there and how beneficial it will be for each and every one of you. When you have all agreed upon the verdict, gives the notion that you still, again, all have to agree unanimously, innocent or guilty. Now, Mark and I had that discussion. He says, well, this works out in your benefit, Derek. If one guy or gal says not guilty, he the whole time knew that I didn't read this thoroughly enough. And maybe he thought I just agreed. And so who is he to contradict my thought process? Who is he to tell me what applies to me and what doesn't? He didn't. He gave me every opportunity, ladies and gentlemen. Oh man, so powerful. Upon the verdict for a count, you will have your foreperson complete the form correctly showing your verdict. Okay? Showing the verdict. It doesn't explain what the verdict is, whether it be a 5-4 split decision or a 3-9 decision. Okay? So, verdict needed to be clarified. Agreed needed to be removed, and something along the lines of, as you cast your vote of conviction, or something along those lines, which is independent of all others, something to that degree. When you have reached your verdict, notify the bailiff that you have reached a verdict. I agree with that. The bailiff will notify the court, and as soon as possible, you will be brought into court to return your verdict. Very well. Doesn't say that it has to be a unanimous verdict, but to come forward with the verdict. The foreperson should bring the verdict form, the instructions, any further instructions given later, and the exhibits to the courtroom. This case is submitted to you November 24, 2021 at, it doesn't have the time on there because obviously that time was put on afterwards, at which time your deliberation are deemed to commence. Which, there's no argument with that last part. What a wonderful, wonderful, wonderful learning experience. So, with that said, do not take your licks and go sulk about it. Put your head in a book and research it. Title 27 CFR, subsection 19.171, surety notice of relief from bond liability. All right, Keith, we'll be talking about that. What else? I was going to touch on something else. I think we'll leave it at that for now. Contract law. There is no law in the United States. Contract creates the law. Equity follows the law. All right? So with that said, thanks for tuning in. Really appreciate you guys. And we'll talk soon.